Mediation is a process based on the interests of the parties, which increases the mediator's rights to the extent permitted by the disputing parties. The story of the apple heart and the rind related to mediation also seems to be easily understood, but at the same time it is considered to be a complex problem. In collective disputes, the rights of Minister of Labor, Health and Social Affairs to receive a report from the mediator comes in collision with the requirement of the normative act to the mediator to keep confidential all information entrusted to him during the mediation process. In fact, this regulation requires a change to specify clearly what type and amount of information a mediator is required to provide to a minister. Also, in this work, confidentiality in mediation, in resolving the property disputes, reality and challenges, is explained the legitimate grounds for the break of confidentiality. In the course of obligation to disclose information by another court decision, the court should only require the disclosure of the information directly related to the case from the mediation participants. At the same time, the restriction that information should be disclosed only to an adequate and proportionate extent to a lawful purpose can be considered as a useful tool for the protection of the legitimate purpose as the confidentiality of information. Ultimately, one of the important functions of a mediator for a successful completion of the mediation in business disputes is to focus on the interests of parties. It is interesting how correct is the record in Article 10, paragraph 7 of the Law of Georgia on mediation, on the duty of protection of confidentiality for an indefinite period. In the mediation process, the parties may not be able to evaluate what information they want to store in future by the confidentiality principle, and what information may be intentionally or unintentionally made accessible or disclosed to the public. Therefore, it may be appropriate to have a record in the future in the Law of Georgia on mediation, following the German model, like after the mediation is completed, if the information is already clear, open and revealed to everyone and to the society, there is no legitimate interest to keep it confidentiality of information and is no longer subject to the protection of the confidentiality principle.